Welcome to the PVW Law Video Library. Today we would like to talk about end-of-life directives, commonly referred to as the living will. We will be discussing advanced directives for the state of Nebraska. However, all 50 states do have different types of directives, and most states recognize the advanced directives properly created in another state. In Nebraska, there are two types of advanced directives. The first is the declaration, and the second is the durable power of attorney for healthcare. The declaration is what most people know as the living will, and is typically a simple document that says, if I am in a persistently vegetative state or if I am terminally ill, I don't want any extraordinary measures to be taken. I want total relief from pain, even if it shortens my life, and I don't want any artificial nutrition or hydration. You may make a direction differently than these examples. You can also supplement the general directions. The power of attorney for healthcare appoints an agent that will be between you and the healthcare system. This document will come into play a little sooner than the declaration. The healthcare power of attorney becomes effective when you are incapable of making healthcare decisions. Someone can act on your behalf before you are in a persistently vegetative state or are in a terminal condition. If you are unconscious and need someone to provide direction for you to the healthcare community, the healthcare power of attorney authorizes your agent to do so. You can also incorporate your end-of-life decisions from the declaration into the healthcare power of attorney. That is, you can provide the agent general authority to act for you, but in the event you become persistently vegetative or terminally ill, your agent is directed, rather than being given the choice, as to your choices concerning extraordinary life support, artificial nutrition, and hydration and pain relief. At PVW Law, we recommend that you consider using the healthcare power of attorney as long as you have a person that you feel comfortable appointing as your agent. Doing so provides someone other than the healthcare system to answer to regarding your healthcare. Choosing a healthcare agent is an important decision. The person who is extremely capable during the day might be challenged at your bedside when you are extremely ill. Before you name someone as your agent, discuss the role with them to determine whether they are comfortable with the decisions that they may be asked to make. Determine your comfort level with their ability to follow through. You can also consider naming a co-agent. Often, an individual with 2 or 3 adult children might name all 3 to act as co-agents. Once you have named an agent, be sure to discuss your real feelings about what you want if you are very ill. There was an early case in this arena where a woman who went into the hospital for hip surgery had her heart stop in recovery. She was not resuscitated. Some clients would say, "Wow, it was just a hip surgery. I would want to be resuscitated." Other clients will say, "If my heart stops, and I don't want to be resuscitated." This is one example of why it is so important to discuss your feelings about what should happen if you become very ill with those who will be overseeing your care. If you would like more information on this topic, you may refer to the news and articles section of our website at pvwlaw.com. If you would like to create a healthcare power of attorney, please go to the Client Tools section at pvwlaw.com and select the Healthcare Power of Attorney intake form.